office, but at this time, I have $8,000 in cash to give to John Conroy from the patients. But anyways, honestly, this whole journey's been amazing for me, and I've met some amazing people. Look at this room. You can see how many amazing people I've met, and I'm very honored to be a part of it with all of you. So anyways, let's have John.
This matter?
I don't know. I always think
It's going now on here, but
The first thing I'm going to do is put this cash somewhere else so that if you're taking all these pictures, they won't think I'm just standing there collecting cash. I hope I don't get stopped on the way home.
it's under 10K, you're all right.
That's... And Neil, you should think of doing that at one of the hockey games or something. You got a good voice.
I'd love to do that. Maybe, John.
Some of you may not know, I actually went to grade 13 in Abbotsford, and I remember this whole area before there was any build-up whatsoever driving out here along the North Parallel Road, and I actually worked in the pipe fitted Kilgard over here for a period of time when I was a student. So this is like old territory for me that I haven't been in for a long period of time. Anyway, so we won a great decision on the 24th. It means that they have to provide that medically approved patients can produce for themselves, or as we've always said, have a true caregiver provide or produce for the patient. They're going to have to put that back in the law at the moment within the next 6 months. As Neil mentioned, they have until the 24th of this month to file an appeal. Given that the instructing client was the former government, and now the instructing client is a sympathetic government, it's possible that they won't appeal. There are a number of other cases that have been going on that they have not appealed or have been instructed to abandon appeals. So it's not unreasonable to think they might not appeal. And if they do appeal, it doesn't automatically knock the 6 months out. They'd have to apply to extend that. And as you probably know from the news, the euthanasia case, for example, they've applied to extend that period of time and so forth. So, but as the judge said in this decision, this is not having to go back to Parliament to have a new act passed. It's a simple matter of amending regulations. And that's much simpler than going to Parliament to have a whole new statute. You're simply saying the governor and council, the cabinet, can pass regulations, and so they can do that fairly simply once they decide the form of them. And they have at least the prior MMAR structure, not that we would necessarily recommend what was in the MMAR. But they have that anyway as a precedent, so it's not that difficult. The interesting part, of course, is that the judge went beyond and made comments on, for example, the evidence of, I'll carry on in this vein. We'll come back to some of the other interesting remarks. But he commented on Jamie Shaw's evidence from CAMCD and the dispensary issue. And he said that the dispensary issue is at the heart of the problem of reasonable access. Remember here, he said that the provisions in the MMPR, the new regs, were unconstitutional in that they took away this right to produce for yourself or have a caregiver do so for you. And in so doing, they restricted unreasonably your entitlement to reasonable access if you're a medically approved patient. So reasonable access is the key phrase that you have to remember in terms of restrictions that were imposed. So you've got reasonable access for patients who are medically approved who want to grow for themselves, whether it's a question of affordability or control over what they put in their bodies or whatever. And while at the moment there's still the DG, the designated grower, as we've always said, the full extent of that under the MMAR is likely to be limited to the true caregiver. Because at the far end of the spectrum, you've got now the licensed producers under the MMPR. Now he also commented about the problems with that structure, that there were so few of them, that they can control price, that alone impedes reasonable access, these sorts of things. So he sort of hinted that the government, in fixing things up within 6 months, coming up with a new set of regulations that works, is that they need to fix that, the LP process. They need to fix the dispensary issue, and that, I think, involves something in consultation with the provinces. And they have to at least reenact or put back in place the ability to grow for yourself or have a caregiver do so. So they have to look at the whole spectrum of supply and ability to produce for yourself. And our view is that they should open up the LP process substantially and have, I mean, there's hundreds of people who've put huge amounts of money into trying to become LPs who are sitting with fantastic facilities able to do so, and yet they've had all kinds of weird excuses given to them for not being able to be approved. So there's something politically that went on there. But my view is that it should be even broader. We don't need all the restrictions and all the excessive costs that those result in for LPs. We have craft breweries and we have large breweries, and we should be able to have craft producers and large producers. And so we should have the whole range. The market will decide, patients will decide whether the product works for them or not. That's how our system is supposed to work. The dispensaries and compassion clubs, in our view, need to be independent of the producers. Unlike Colorado, which is a vertical integrated model, we say that's fine in a legal model where it doesn't matter if Labatt's owns the pub and is promoting their product in the pub, but it does matter when it's medicine, so that we don't have this problem that we have currently with the pharmaceutical industry and the doctors, where they send them on trips and pay them this and that in order to always prescribe their particular drug or use their particular sample. So there's that whole ethical problem that arises. So similarly, we don't want to see dispensaries wholly owned by LPs, so that there's a control thing in terms of their product. That too would impede, we think, reasonable access and independent decisions by doctors. And hopefully it'll be more than just doctors. You know, the doctors resist being the gatekeepers, but they also resist having naturopaths and doctors of traditional Chinese medicine, people who know something about whole plant medicine, from being involved. So that's another issue that has to be opened up in order to ensure that people who know something about whole plant medicine are involved in it. So he's made this decision. They've got 30 days to appeal it. They've got the 6-month issue. It's a regulation, so it's easy to do rather than a problematic thing of having to go back to Parliament. And the hints are all there for them to address more than just personal production and caregiver production, to really try and grapple with the other part of it. Now in turn, of course, we know we've got a government that's in favor of legalization. They have said and done more than previous governments in terms of saying they're going to legalize. I've been around for a long time and have seen various promises, at least 4 in my time, of various different ways that they said they were going to decriminalize or legalize or whatever. And usually when they get in power, there's more important things to do and they don't follow up. This government has actually put it in writing to the Minister of Justice, to the Minister of Public Safety, and the Minister of Health. It's part of the instruction from the Prime Minister to them that this is part of what they're required to do. They're stalling a bit with Bill Blair, the former chief of Toronto Police, being the sort of point guy, which is a bit concerning to have when we're trying to get rid of the police model to have a policeman in charge. But we need to see who his task force or other people are going to be, hopefully to balance it out. I mean, they're talking about doing it right and restricting access to young people and things like that. And I finally think I've managed to get my thoughts anyway to the policy person in the Liberal Party to get to Bill Blair so that at least I can feel that it had some say. David Malma-Levine has put a package together, well researched, that has some very good points and things in it as well, that he delivered to the Minister of Justice. So the message that some of them received from the Allard decision, certainly talking briefly to Larry Campbell in the Senate, was that it had some impact in Ottawa, and it makes sense that if they're going to try and grapple with dealing with medical, they could also deal with social and legal at the same time. Because, and I think this is some of the most important thing that came out of Allard, is that Judge Phelan found Corporal Humquist to lack credibility, to be biased, and his evidence was not to be accepted. And the same with Fire Chief Len Garris, the guy from Surrey who used to, maybe still goes around, going on and on about all these problems of fire, mold, and public safety. And as we established in the case, Health Canada had no single statistic of any such problems with any approved medical facilities. And all of the police evidence, or certainly 99% of it, was all illegal operations and hyperbole from the police and the fire people. So here's all the stuff that whips up people's fears, particularly local politicians, and you know, they keep reciting it, and the judge found it to lack credibility. So hopefully that sends a message to some of the politicians and people, you know, not to be so fearful. We are in 2016. We're not back in 1916 or 1920. People forget that prior to 1923 and even right up until 1949, cannabis was on various pharmacopoeia and medical codexes in the UK and the USA, and that there was no particular cannabis issue going on in Canada. There were medical tinctures and so on. You can go on the internet and you can have pictures of all of these things. It was a natural healthcare product. Convicted, stay of proceedings, withdrawal, even acquitted. Your name will be in a police database if you were a passenger in a car that happened to have somebody who had a joint in the car. And you will be prejudiced by the disclosure of that stuff in the database. So we're way past the criminal record causing problems that existed in that period. So anyway, we've progressed now to a stage where we actually have a government that says it's going to legalize. And so there's some huge questions because it's very, very easy to legalize, notwithstanding all of the things that slowly, you know, somebody raised international treaties the other day. Well, international treaties aren't the law of the land. The law of our land is, the Constitution is the supreme law, and the Charter of Rights is the supreme law. And any laws that Parliament passes have to be subject to the Charter. Treaties are not part of the law unless we pass a law to make them part of the law, to implement them. That's the law in Canada. And so the Controlled Drugs and Substances Act, with its power to exempt, with its other powers that are being used, is part of the law of the land that implements those treaties. So we don't need to worry about the treaties, and to the extent that the treaties are inconsistent with the Constitution, you know, they're not worth anything. And you can always withdraw from the treaties as well. So there's the other thing. Now, a big thing that I think everybody really needs to think about in terms of the legalization, well, remember, all they have to do is, again, they don't have to go to Parliament. They can just pass an order in council, a cabinet order, under Section 60 of the Controlled Drugs and Substances Act, removing cannabis from Schedule 2 to the Controlled Drugs and Substances Act. You don't have to repeal the Controlled Drugs and Substances Act. You don't have to pass a new law. You don't have to recall Parliament. You just could pass an order in council and cannabis would be legal. It would no longer be subject to the criminal law. Decriminalization or legalization would have taken effect. Medical would immediately be covered by the Natural Healthcare Products regulations under the Food and Drugs Act. And they're not soft regulations, they're pretty onerous regulations as well. And so, but right now, any drug in the Controlled Drugs and Substances Act or in Schedule 2 to the control is expressly taken out of the Natural Healthcare Products regulations. And let's face it, cannabis is essentially a natural healthcare product. It's like the other plant medicines. Sure, you can make a pill, you can make a spray like Sativex or these other things, and if you do have to go through the approved drug process and all the rest of it in order to take that to market. Some have done that and successfully. But when you're dealing with it as a plant, that's the problem. Doctors, they can't, many of them get their heads around dealing with a plant and how much you should consume smoking or vaporizing or whatever. That's just not what they're used to. And yet they resist, as I said earlier, the issue of control or participation by naturopaths and others who know something about it. So, what should the age limit be when they legalize? That's what most people say, 18 because that's tobacco, 19 because it's alcohol. The Senate said 16, and I agree with them. You know, what is a child? 12 is the legal age in Canada. And the reason, you know, we got to remember that our whole point in terms of legalization is not to make it easy for adults and keep screwing young people. It's supposed, we have to accept that the use of the criminal law, the big stick of the criminal law, causes more harm to young people and others than the consumption of cannabis. That the police model needs to be taken completely out of the equation. It's not let the adults off and keep busting the young people and prejudicing them for the rest of their lives. That's crazy. That's not protecting young people. So we need to make it clear to this government that restricting access to children means educating parents, getting teachers involved to educate parents and educate children, and having the educators as the model, and parents and educators, not the police. You know what they do for prescribed drugs? I went into the pharmacy a few months ago and there was a pamphlet and it said 80,000 kids got the highs getting drugs from their parents' prescribed drugs last year. And on the right it said, here's what you need to do. Lock up your drug. Count your pills. Get rid of your old ones. It didn't say bust your kids and turn them in and use the police and give them a criminal record and prejudice them for the rest of their lives because they got high using a drug that could kill them, you know? But if you use a drug that can't kill you, so You know, we gotta get over this business that protecting children is using prohibition. That's the problem, you know? I make money as a criminal defense lawyer the more things you prohibit and criminalize, and I'm telling you, it's stupid. It's absolutely stupid. It's the worst possible way to try and regulate or control something like this. So you've got to remember, don't fall into that, oh, alcohol and tobacco. And that leads to this other issue. They want to use, I don't have a problem with the Shoppers Drug Mart, the drug pharmacies and so on as far as medical distribution is concerned, as long as you allow for independent dispensaries. But selling cannabis in liquor stores, whether government or private, again, it's a natural thing for people to think that because they think of cannabis being, oh, it's like alcohol or tobacco, but it isn't. And we don't want, if we're going to accept the 16-year-olds as the age limit, surely we don't want only access to be in a place where 16-year-olds can't go, you know, and then introduce them to what is our number one drug problem, alcohol, which has been our number one drug problem throughout this whole period, you know. So sure, we can look at how we deal with alcohol in terms of coming up with a model. We can look at how we deal with tobacco in terms of coming up with a model. But cannabis is different. It's not the same as alcohol. You know, impaired driving. Impaired driving is a huge thing. And there's this great fear, understandably, that if everybody's consuming cannabis, there's going to be this huge increase in impaired driving and people dying and all this sort of thing. And again, it's a huge overstatement and whipping up of fears. We have had laws in Canada since I've been practicing, and long before I started practicing, and that's now 45 years, where there's a law that it's against the law to drive under the influence of alcohol or a drug while your ability to do so is impaired. And the traditional way of enforcing this law has been to either suspect something at a roadblock, get a report of erratic driving, observe some erratic driving, pull you over, make you do roadside tests, where they actually test your motor coordination skills. There is no magic machine to measure impaired by cannabis. There's lots of machines that will measure that you've consumed cannabis, but merely having consumed cannabis is irrelevant to your ability to drive while impaired. And so, especially in the case of medical patients, and this is a huge problem right now in Washington State, you have hundreds, if not thousands, of medical patients who are way over the presumed 5 nanogram impaired driving. And they're not impaired at all, not in the least. And so their ability to drive is not impaired. Are we to presume them to be impaired and not allow them to rebut that presumption simply because we arbitrarily picked 5 nanograms? In Colorado, at least, it's rebuttable. You can show that you're not impaired. And, you know, people here may have to go to ICBC and have these special tests done to show what your baseline is and so on, like some of us old folks when we get too old to drive. And, you know, so that at least if you get stopped, you're going to be able to take the package out and show the officer what your baseline is and have something there to raise questions about whether your ability to drive is impaired. I mean, don't misunderstand me. Novice users of cannabis, irregular users of cannabis, most users of cannabis should not drive shortly after they've consumed it. Probably should wait a half hour at least. If you've eaten it, of course, it's not going to take effect for about an hour, so you may have to drive quickly to get to your location. Here are the differences, you know, it's not the same as booze. The studies show that the marijuana drivers are more careful, they're more conscious of their situations and so on. But hey, you might stop where there isn't a stop sign, or you may see or be distracted by something else. So your ability to drive definitely can be impaired, so don't misunderstand me. But I'm saying we have to have a fair system. You can't criminalize people who are not impaired. You have to allow for the reality of what the facts, what evidence is. And look back since the 60s and 70s, and we actually have a reduction in the number of crashes on the big scale, including the time when marijuana was popular in the 60s. So if you actually look at the facts and figures and so on, there's a reduction. And we have not had, in the past, a huge problem with impaired driving by cannabis. And there's conflicting studies in Colorado and Washington State at the moment, but the majority or the weight seems to be pointing towards the problem of them saying there was cannabis in the person's system, not that it was a cause or contributed to the accident. So impaired driving, getting the medical thing right, and getting the legalization thing right, and not following some of the U.S. laws where it's announced. I don't know if you knew, if you're in Washington State, if you have more than an ounce, it's illegal. If you are on federal property, it's illegal. So that's not legalization under my view of things. Legalization under my view of things is that you can lawfully possess it and so on, that the market is essentially flooded so that there is no more interest on the part of organized crime to be involved in it whatsoever. And there's no concern about grow rips and all of these sorts of things. And people can have an orderly, regulated market like many other things and not have to have the criminal law involved. I've been practicing law, as I say, for over 45 years, mostly as a criminal defense lawyer, and I would not recommend it as your approach to solving any social problems whatsoever. I think that's probably enough. I covered as many issues as I can. We are, oh, I have to say this, most importantly, I almost forgot. While we won, we only won to this extent. We've got 6 months for them to fix things up. But remember, there's all kinds of patients, medically approved patients, who didn't fit within the injunction. The judge particularly was restrictive, he said, so that he wouldn't interfere in the proposed legislative scheme. So it was a balancing of convenience at the time of the injunction. The court has now found that the constitutional rights of medically approved patients were violated by the restrictions in the MMPR. All MMAR medically approved patients, not just those whose production license were valid on September 30th and their authorizations to possess on March 21st, 2014. They know that there are people who fell, I say, between the cracks of that injunction. We have people whose ATPs expired, and Health Canada still said having a Section 53 narcotic control authorization wasn't good enough. So we've got a whole bunch of people in that database who are approved, who still can't produce or even possess, although if they got a 53, they can at least possess. So we are in the process of arranging to get back in front of Justice Phelan on April 22nd, probably. It's not cast in stone yet. And we will be seeking to have him either grant an exemption to all medically approved people. In Smith, in the Supreme Court of Canada, when they struck down the dried marijuana limitation and said everybody can produce and possess cannabis in any of its forms, they didn't suspend that declaration. They made that declaration effective immediately, and they said because otherwise medical patients will be without their medicine. And our judge, Phelan, while he wouldn't grant us a variation before, because he said it was premature, he did raise, at the end of his July 15th decision, the possibility of a remedies hearing afterwards. So it was a bit surprising to see that all he did was continue the injunction and not address all of the medically approved people who weren't covered by the injunction. So we hope to go back on the 22nd to get those people covered, to get everybody who is in the database at least at the beginning of 2013, and we put in some alternatives in what we've drafted. That, and the most common question that I get in my office or in my email is, can I move my license? Can I move my production site? Even if I post it on the web page and all kinds of places, it remains the most common call that I get. And so that, of course, is the other thing. We've got people who've had landslides where their house is unsafe, and they've got a better place to move it to. Why can't they move? So we're asking that the federal government force the Office of Medicinal Cannabis to accept changes of address using the old sections of the MMR in terms of what information needs to be provided until the government fixes it up. So our hope is that everybody who was medically approved in 2013 to March 2014 will be covered until the government comes up with its new model, whatever that might be. Now, history being what it is, it took us 10 years of going to court under the MMAR to remove its restrictions. Hopefully, we're not faced with the same situation with a liberal government that favors legalization. Hopefully, this government will get it right and figure out that it's not that complicated and get it done, and then I can retire. Thank you very much.
We have a nice $1,000 donation from Croc King Seeds. So really, if I add it up here, because I think we're over $10,000 because we have the 8, there's 9, we got 250 from the cannabis growers, and we got 500 from Scotty and the beer grows. I know Michael James from Manitoba, Mike Milne, I know he's offered to donate $1,000 for every 5,000 that I donate. So, have some good money for the patients. So, we just gotta get their name on here. And I'd like to really thank John for coming out and speaking, and all you guys for coming out and celebrating with us.
Thank you to all the patients. The donations that have kept this thing going have, the greatest amount have been from medically approved patients, many of whom are on disability pensions who can least afford it. So thanks very much. It's been great, and we're going to get it done, and we're going to get it done right. Thanks again.